Hello, hello. I'm going to put our thumbnail up. I'm so sorry. I'm so sorry. All right, so yeah, hard case today. Tracy Nicks. And we're going to take a little bit of a deep dive into this. Florida mother was left with mixed emotions after the jury ruled that her mother was not guilty of aggravated manslaughter in the hot car death of her 7-month-old daughter, Uriel, known as Yuri to them. Tracy Nicks is 67. She was convicted on Wednesday, today, of leaving the 7-month-old unattended in a vehicle longer than 15 minutes, which caused great bodily harm. That's her death. Uriel shocks. A jury found her not guilty of aggravated manslaughter of the child. Following the verdict, Tracy Nicks was walked out of the Hardy County courtroom. She was remanded. She was to be delivered into the jail without bail. She is going to be in custody until her sentencing, which is on April 3rd, I believe. Let's see what we got here. Now, a reaction from her daughter. "It does sting," said Drew Shock, Uriel's father. "I'm thankful, though, we did get something." And Kayla Nix, Tracy's daughter, says, "I was relieved to hear that there was going to be accountability and ownership and a conclusion to this part of the story." Kayla Nix had to step out of the courtroom after seeing her mother be taken away in handcuffs. The last few years have been complicated for her. Now, there were people in the trials. I just have to not even pay attention to the chat in most cases. I usually just put my trial on full screen and ignore the chat. There were people that were saying the daughter was in handcuffs, that, yeah, I mean, the most crazy things you could imagine. But Kayla left her 7-month-old daughter, asked her mother to watch her 7-month-old daughter while she went to a hair appointment. This was November 1st of 2022. And it had a horrible outcome. The mother took the baby to a church group meetup at a restaurant and then put the baby back in the car with the diaper bag and everything, drove to her house, right to her house. There were roofers there. She couldn't put her vehicle where she normally did. She didn't really even remember where she put it. She put it, she parked the car. Allegedly, she took the diaper bag as well into the house, and she talked to her dog, and she played the piano to practice for an upcoming recital or something for hours, and then she got in her car and still, even at that point, was not remembering the baby. When she went out to the car and got into the car, she was thinking about her other daughter was going to be bringing her grandson. They were going to go out of town. I believe they were going to do some Christmas shopping or something, go to a restaurant, and she was thinking about that. And then when she went to go feed the pigs at the barn, she got in there, she drove the car down there, and then her husband had been there, allegedly, and something jogged her memory then. The husband, the grandfather, took the baby out of the hot car, put her down. I think it was a picnic table. They were trying to give her CPR. The other sister arrived. She called 911, but even that was a little bit strange because I don't know why the sister called 911, yet she was getting in the car to leave because she didn't want her son to see any of this. And so even the 911 dispatch was like, we need to talk to the people that are around the baby, that are giving the baby CPR and stuff. And it was just so convoluted. That was so ridiculous. And they asked her to give the phone to the mother. They had asked the mother how long she'd been in there. It was a while. Now, what we're going to talk about is that there's a lot of stuff about with the mother's medication usage. And the mother was on a variety of medications. And after the jury went to deliberate, the defense team started to call witnesses. And they basically had the control of the courtroom. They were trying to get testimony on record. And the testimony that they were getting on record was from like psychiatrists and doctors that specialize in pharmacology, and they were talking about these medications, and they were talking about this Beers list, this Beers chart, which is a chart that's originated in 1991. So like they were saying, this is not something that is speculation. This is not something that is, new. This is something that has been around for a long time, and about the adverse effects of elderly patients. And you're in the 60s, you're considered elderly. I think you're considered elderly even way before that. When you're on these medications, they can cause a myriad of problems. And these people of this age are not supposed to be on these medications, not at these combinations, not at these levels, not long-term usage. And all of that can contribute to memory problems, falling asleep, drowsiness, falls, just confusion, no attention span, all kinds of things like that. And so when one of them said, I believe, that they thought that she might have the beginnings of dementia, but when she was off of all these medications, which was April of 2023, and they had seen her in the fall of 2023, she didn't have any of those signs of dementia. So they're trying, I guess, to get that on the record for an appeal, because the judge did not allow that in the trial. And what I really wanted to see is they had an expert on there, an expert in memory and why people were leaving children in these hot cars, people that are younger, people that are not on drugs like this, why this phenomenon, why this huge uptick in these hot car deaths. And then just as that person was speaking, the jury came back, and that was it. I thought they'd go back to the end, but I didn't see it. It might be somewhere else. I don't know. I really wanted to hear that. I think what it's going to be is about devices and distractions and all of that. But anyway, jury came back, got the verdict, right? So not guilty of the aggravated manslaughter, guilty of the leaving that child in that car for more than a period of 15 minutes, causing great bodily injury. Sentencing again, April 3rd, I believe it is. And so we're going to talk about it all, and we're going to go over the case. Okay. So medical examiner testified today that she died of hyperthermia. It means her body temperature went way too high. And then the exclusion of the sibling of Yuri, who died drowning in a pond, has been something that Kayla Nix said, and I quote, "One of the things that we have struggled with through this whole case has been the exclusion of my other story, which is my son, who drowned in her care." Due to the ruling by the judge, jurors did not hear anything about Kayla Nix and Drew Schock's other child, Ezra, who died before Uriel. "The destruction that has come from this process is pretty unfathomable," said Kayla. "My kids are dead, but I've lost a lot more than that." The state tried to show that Tracy Nix's negligence was criminal, or, in other words, culpable. The prosecutor, Timothy Coleman, called family members and spoke to them, including Kayla Nicks, friends, law enforcement officials, and the associate medical examiner. Coleman showed videos of Tracy Nicks and Uriel Schock having lunch with friends at Beef O'Brady's before Tracy Nicks drove home and left Uriel Schock in the car. He also showed body-worn camera video from the scene at the Nicks home and an interview with police. During closing arguments, Coleman asked jurors to hold her accountable for failing Uri. Hold her responsible for that culpable negligence of not paying attention to her, of leaving her trapped and alone. Find her guilty as charged. Instead of culpable negligence, Nicks's attorney, Bill Fletcher, said this was an accident and said, and I quote, "Please don't make this terrible situation worse by convicting Tracy Nicks of something that she's not guilty of." And that was said during his closing arguments. And after the verdict, Fletcher said he considered the aggravated manslaughter acquittal a win. And I quote, he said, "I want to thank the jury. They did their job. They made an appropriate decision in this case, and we certainly intend to appeal." Fletcher said the judge did not allow intent to be included in the jury instructions for the charge which Tracy Nicks was convicted. She will be sentenced in April, and she faces up to 5 years in prison. Okay, so let's go into this a little bit further, okay? Kayla, who had an older son named Asher and was 6 months pregnant with Uriel when her other child drowned, said she rushed to her parents' home driving 85 miles per hour and getting in a head-on collision on her way as she watched a helicopter head towards their address. She said she could see the helicopter landing. "I didn't look when there was a stop sign. All of my airbags went off. I don't remember how I got out, but I got out and I started running towards my parents' house, and I didn't even have shoes. I'm just running. That was desperation to get to my son." But by the time she arrived at the house, Ezra was already dead. Police had attempted to file the charges at Tracy Nicks at the time, but the Florida Attorney's Office stated that a one-time lapse of judgment would not establish culpable negligence of the caretaker. Yet when the parents were forced to rush back to Tracy's home in November, 11 months later, Drew said he started to have flashbacks. "When I pulled up to the house, I'm coming to pick up my little girl, and there were ambulances there, and I'm thinking, what the... something is going on. I was having flashbacks because when I pulled back with Ezra there, it was the same exact pulled up with Ezra there. It was the same exact scene. Police showed up at the Kayla's door to share the heart-wrenching news, but the mother was confused. I'm sorry, what? I know Ezra's dead. Why are you here? What is this?" Kayla recalled. "No, Kayla, your baby is dead," they told her. "You couldn't fathom it was happening twice. Somebody has to answer for that." In court, Fletcher framed the tragedy as an accident, begging the jurors on Wednesday to not make this terrible situation worse by convicting Tracy Nicks of something that she's not guilty of. He also noted in the opening statements that Tracy was a former teacher, a principal, and a church member. He said she just made a mistake. Fletcher now plans to use expert testimony that could not be brought up at this trial that states that Nicks was taking a very high, a double dose of Ambien that she was prescribed when she watched Uriel that day. She's very well known and very well respected, and it was the medication really, he insisted when he spoke to media like Fox 13. But as he prepares his case, Kayla said she will continue to push for answers as to why charges were never brought up in Ezra's case. And Father Drew says that they now plan to spend time with their older son Asher and a newborn daughter. We're always going to be thinking about our children. It's a day at a time. Asher, what was the new baby's name? I forget. Here's a picture when the grandmother was it says blessed to be called grandma. The temperature was over 90 degrees when Uriel was left in that car. Emotional testimony happened on Tuesday. Attorneys gave opening statements, and I'm going to quote some of them. We are here today and for the next few days not to determine if Tracy Nicks was a good person. We want to focus on her actions, her inactions, and results of her actions. And that was said by Assistant State Attorney Timothy Coleman. She's a former teacher, principal, and a church member who just made a mistake, said Nicks's attorney, William Fletcher. It was a tragedy that does not need amount to a crime under Florida law. Here's the mother when she was on the stand. Kayla Nicks became emotional when talking about having to identify her daughter's body on November 1st. It was sheer anxiety, Kayla Nicks said, appearing to hold back tears. Friends who met Tracy Nicks for lunch that day also testified, saying they've known her for decades and she was a loving grandmother. There was a 911 call. Tracy Nicks's daughter and baby Uriel's aunt, Rebecca Tucker, arrived at her parents' Wauchula home on the afternoon of November 1st, 2022, and they found a frantic scene as the baby's grandfather was giving little Uriel CPR. Her eyes are open. She's not moving or breathing, Tucker said during her call, which jurors heard on Tuesday. Mom, how long has she been in the car? A while, Tracy Nicks responds. On Tuesday afternoon, jurors also watched body cam video from a Hardee County detective. And Tracy Nicks said in that, I don't want to face anybody. I can't face my daughter. I cannot do that. Detectives then took Tracy Nicks to the sheriff's office and questioned her there. Let's see. So they have a daughter that's going to be 5 months old. Don't know what the daughter's name is. And so I heard that they are going to try to look at Ezra's death. Let me see here. So let's talk about some of the medication that Tracy Nicks was on and some of the testimony from these experts that took the stand. And we're going to look at that Beers report, as I looked at that earlier. And she also was brought up to the stand and said that she wasn't going to testify. That's something I saw in that Georgia case. The judge name is Rafool, Judge Rafool. Okay, so let's see what we got here. I am so cold. The medical examiner said this was not sudden death. She said quick but not instant, could mean an hour, when defense questioned her. She then told the assistant state attorney that Uriel was alive long enough to sweat and produce the amount of sweat she did. Tracy Nicks's husband and father of Kayla Nicks, whose daughter Uriel was left in the back seat of her mother's car, was sworn in to testify. Tracy Nicks was sworn in, and then the judge asked if she has chosen not to testify in this case, and Tracy said she's relying on her lawyer's judgment not to testify. There was a hesitation because of that. They made a break. She spoke with their attorneys, came back on the stand again, and said, she decided not to testify, and no one's, pressuring her to do that or not to do it. After approximately 3 hours of deliberation, the Hardy County jury found Tracy Nicks not guilty of aggravated manslaughter. She was found guilty of a lesser charge of leaving a child unattended in a vehicle for more than 15 minutes. I want to get to that testimony about the medications, and I don't understand why it wasn't introduced. I'm not sure about that, and let me make sure that we are live and all of that good stuff. Hello, I'm going to put our okay, here we go. My wife got a total charge from it though. Judge Rafool. Oh yeah. Hello, Heart Made Wise, Bucky Ann, Captain Lee, Lil Lighty, and Kevin, White Angel. By the way, we both got off. Wait, what happened? Hold on a minute. Did you say Bucky Ann? I was on that for a year. Couldn't remember getting up to drive my son to school, but I did. My aunt woke up sitting in the street with a cop telling her she was in a car accident. Which one are you talking? Xanax is the #1 memory killer. Yeah, and it's especially not good for people in their 60s at all. My aunt said, I went to bed last night, woke up in the street. I don't remember being up or driving at all. By the way, we both got off Xanax immediately after that, because how was I doing things like that? Phone's going to die. You're going to switch to your TV. Okay. You're having coffee and trying to wake up. I'm here, everyone. I'm here. Kevin's here. All right. Just hang on for like 2 seconds. I have to get something that I'm going to try to find this testimony about. I'm going to show you the Beers report, okay? Oh my gosh. I knew something I had to sell at the auction, White Angel, and I didn't do it, and it's something that you wanted. I knew I had other stuff to sell. I'll have to save it. I don't even know where the freak it went. Because it was, for crying out loud, I had it somewhere over here. I don't know where the heck it went. That's so weird. Where did it go? Watch the Beers report. It's the American Geriatric Society, and it's been updated 2023. And this is what it is. The American Geriatric Society, ACS, Beers criteria for potentially inappropriate medication used in older adults is widely used by clinicians, educators, researchers, healthcare administrators, and regulators since 2011. The AGS has been the steward of the criteria and has produced updates on a regular cycle. The AGS Beers criteria is an explicit list of PIMs that are typically best avoided by older adults in most circumstances or under specific situations, such as in certain diseases or conditions. For the 2023 update, an interprofessional expert panel reviewed the evidence published since the last update, which was 2019, and based on the structured assessment process, approved a number of important changes, including the addition of new criteria, modification of existing criteria, and formatting changes to enhance usability. The criteria are intended to be applied to adults 65 years old and older in all ambulatory, acute, and institutionalized settings of care except hospice and end-of-life care settings. Although the AGS Beers criteria may be used internationally, it is specifically designed for use in the United States, and there may be additional considerations for certain drugs in specific countries, whenever and wherever used. The AGS Beers criteria should be applied thoughtfully and in a manner that supports rather than replaces shared clinical decision-making. The Beers criteria was developed by the late Mark Beers, MD, and colleagues at the University of California, Los Angeles in 1991 with the purpose of identifying medications for which potential harm outweighed the expected benefit, and that should be avoided in nursing home residents. The 1997 update, led by Dr. Beers, explained the criteria to apply to all older adults. The criteria was updated by an interprofessional group in 2003, and the American Geriatric Society took over stewardship in 2010. The 2023 American Geriatrics Society, Beers criteria for potentially inappropriate medication, PIM, use in older adults is the 7th overall update and 4th since AGS became the criteria's steward. Let me pull this over so you can see this. Okay. As with previous updates, the AGS and its expert panel attempted to preserve the spirit and intent of the original Beers criteria by providing an explicit list of potentially inappropriate medications that are best avoided by older adults. So let's just take a look at some of these medications and the ones she was on, because she was on Ambien and she was on Ativan, and she was on, I'm trying to think if what was she on? Okay, so let's look at some of them. And why is this one table is strong, weak, arms, okay. I don't know. Digoxin, that's for first-line treatment of atrial fibrillation or heart failure. Use in atrial fibrillation should not be used as a first-line agent because there are safer and more effective alternatives for rate control. Use in heart failure, evidence for benefit and harms of digoxin is conflicting and of lower quality. Most, but not all, evidence concerns use. There is strong evidence for other agents as first-line therapy. So they're saying that these are not good to use in individuals over 65. Antidepressants with strong anticholinergic activity alone, which is amitriptyline, and she was on amitriptyline, I believe. That's what they said. I believe that was amitriptyline. Amoxapine, clomipramine, desipramine, doxepin, imipramine, nortriptyline, paroxetine. They say they're highly sedating and they cause orthostatic hypotension. The safety profile is comparable to the, okay, blah, blah. Okay, anti-Parkinson's agents with strong anticholinergic activity, benzotropine, trihexyl, phenadol, antipsychotics, aripiprazole, haloperidol, olanzapine, quetiapine, risperidone, others. Increased risk of stroke and greater rate of cognitive decline and mortality in persons with dementia. Additional evidence suggests an association of increased risk between antipsychotic medication and mortality independent of dementia. Okay, barbiturates, high rate of physical dependence, tolerance to sleep, benefits greater risk of overdose at low doses, benzodiazepines, alprazolam, chlordiazepoxide in combination with amitriptyline or clonidinium, clobazam, clonazepam, clorazepate, diazepam, estazolam, lorazepam, midazolam, oxazepam, temazepam, triazolam. And it says the use of benzodiazepines exposes, I hit my leg, users to risks of abuse, misuse, and addiction. Concomitant use of opioids may result in profound sedation, respiratory depression, coma, and death. Older adults have increased sensitivity to benzodiazepines and decreased metabolism of long-acting agents. Well, they also said that women metabolize much slower, so this stays in them. And she was taking a very high dose of Ambien and decreased metabolism of long-acting agents. The continued use of benzodiazepines may lead to clinical significant physical dependence. In general, all benzodiazepines increase the risk of cognitive impairment, delirium, falls, fractures, and motor vehicle crashes in older adults. May be appropriate for seizure disorders, rapid eye movement, sleep, behavior disorder, benzodiazepine withdrawal, ethanol withdrawal, severe generalized anxiety disorder, and periprocedural anesthesia. Non-benzodiazepine receptor against hypnotics. Benzodiazepine receptor against hypnotic or Z drugs have adverse events similar to those of benzodiazepines in older adults, e.g. delirium, falls, fractures, increased emergency room visits, hospitalizations, motor vehicle crashes, minimal improvement in sleep latency and duration. Then meprobamate, high rate of physical dependence, very sedating. Ergoloid mesylates, dehydrogenated ergot alkaloids, lack of efficacy. Then we have androgens, methyl testosterone and testosterone. They have a potential for cardiac problems, potential risks in men with prostate cancer. Estrogens with or without progestins include natural and synthetic estrogen. Evidence of carcinogenic potential breast and endometrium. Lack of cardioprotective effect and cognitive protection in older women. For women who start HRT at age 60 and older, the risks of HRT are greater than the benefits, and HRT is linked to a higher risk of heart disease, stroke, blood clots, and dementia. That's hormone replacement therapy. Not mistaken, right? Evidence includes that vaginal estrogens for the treatment of vaginal dryness are safe and effective. Women with a history of breast cancer who do not respond to non-hormonal therapies are advised to discuss the risks and benefits of low-dose vaginal estrogen, e.g. dosages of estradiol twice weekly with their healthcare provider. Okay. Insulin, sliding scale. Insulin regimes containing only short or rapid-acting insulin dosed according to current blood glucose levels. Higher risk of hypoglycemia without improvement in hyperglycemia management, regardless of the care setting. Avoid insulin regimes that involve only short or rapid-acting insulin dosed according to current blood glucose levels without concurrent use of basal or long-acting insulin. Sulfonylurias, they have an increased higher risk of cardiovascular events, all-cause mortality, and hypoglycemia than alternative agents. Sulfonylurias may actually increase the risk of cardiovascular death and ischemic stroke. Among them, long-acting agents like glyburide, glimepiride confer a higher risk of prolonged hypoglycemia than short-acting agents. Megestrol has a minimum effect on weight and increases the risk of thrombotic events and possibly death in older adults. Growth hormone. Impact on body composition is small and associated with edema, arthralgia, carpal tunnel syndrome, gynecomastia, and impaired fasting glucose. Gastrointestinal, the protein pump inhibitors, lansoprazole, whatever, all this prazoles, omeprazole. Risk of C, infection, pneumonia, GI malignancies, bone loss, and fractures. Metoclopramide can cause tardive dyskinesia. The risk may be greater in frail older adults with prolonged exposures. GI, antispasmodics with strong anticholinergic activity. And then there's demopressin, high risks of hypoatremia, safer alternatives. Okay, pain medications. Aspirin, greater than 325 milligrams a day. Diclofenac, diflunisal, etodolac, fluorobiprofen. Yeah, she was on some kind of medication. He said it was like an ibuprofen, but it was a very high dose. I forget what the name of that was. Okay, so let's see. Hi, everybody in the chat. Just going through this. Hi, UHP, and everybody. Thanks for coming in. Increased risk of GI bleeding or peptic ulcer disease, including those if you're greater than 75, taking oral or parenteral corticosteroids, anticoagulants, or antiplatelet use of protein pump inhibitor or misoprostol reduces but does not eliminate risk. Ibuprofen, indomethacin, ketorolac, naproxen. Naproxen is Aleve, so avoid short-term scheduled use in combination with oral or parenteral corticosteroids, anticoagulants, or antiplatelet agents unless other alternatives are not effective and the patient can take a gastroprotective agent. Okay. Ketorolac, increased risk of GI bleeding. Meperidine. Then there's the skeletal muscle relaxants. Crisprodol, chlorzoxazone. She was taking Flexerol, cyclobenzaprine, metaxalone, methocarbamol, or phenadrine. Muscle relaxants typically used to treat musculoskeletal complaints are poorly tolerated by older adults due to anticholinergic adverse effects, sedation, and increased risk of fractures. Effectiveness at dosage tolerated by older adults is questionable. Cardiovascular drugs, central nervous system drugs, opioids, dementia or cognitive impairment, history of falls or fractures, benzodiazepines, antipsychotics, antiepileptics, SSRIs, SNRIs. I think she was on, somebody said Cymbalta to it. History of falls and fractures, Parkinson's disease. So yeah, I mean, there's a lot of things that are not supposed to be taken, and they did say, well, does this open them up to a malpractice? And yeah, I mean, that's what they were saying. So that look like that could be a very real scenario about the doctors. Now let's see what this is. Antidepressants, quinidine, cardiovascular, baclofen, duoxetine, gabapentin, reduced dose, central nervous system adverse effects, levetiracetam, the NSAIDs may increase the risk of acute kidney injury. So, I mean, yeah, independent of diet. They said, so that's, I assume, is going to be under appeal. I don't know why they didn't let it in. They claim she's not on any medication now, and that she was very confused. Now, here's the conclusion. To bring the expertise of geriatrics to the public, it is the hope of the AGS and the 2023 AGS Beers Criteria Expert Panel that the updated criteria will be used as intended to improve drug therapy and outcomes for all of us as we age by identifying and reducing prescribing of PIMs in older adults through a process of shared decision-making that focuses on goals in care. Okay, so, wow, there's a lot of bad, yeah. And she was on, let's see if we can get her list of medications. Okay, let's all right, so let's see what we got here. There's some information here, and I want to look at this, whatever this is here. The court sees nothing in the record to establish that the defendant actually suffers from senility. The experts would therefore serve to stack inferences that she is, in fact, senile, and that the condition was exacerbated by inappropriate medication and or habit memory. The court further notes that at the hearing, the defense was asked to explain, in particular, Dr. Diamond's methodology and was unable to do so. Based on the above, the court cannot find that the expert's testimony is admissible under the Daubert standard. It is therefore ordered and adjudged that the motion is granted. No defense testimony regarding the defendant's purported senility or mental health issues, nor any expert testimony bolstering such evidence shall be admissible at the defendant's trial. The defendant is also prohibited from presenting any expert testimony or evidence related to the diminished capacity to show that the defendant lacked the mental state or mind required for the charged offense, but such evidence would be admissible at disposition should the defendant be found guilty. And that's why I guess they were doing that today. That was ordered and adjudged December 23rd, 2024. Okay, let's see what else we have. The defense claimed its experts would testify from related but different scientific areas. Its response asserts that Dr. David Diamond, an expert in memory and cognitive processing, would explain the difference between habit memory and how it can override prospective memory. Dr. Daniel Buffington, a neuropharmacologist, would testify about the long-term neurological impact of the defendant's prescribed medication. And Dr. Ryan Estevez, a forensic geriatric neuropsychiatrist and expert in aging, senility, and neuropharmacology, would testify about the impact of aging on the brain as well as the impact of certain prescribed medications on elderly patients. Trial courts have a gatekeeping responsibility to ensure that any and all scientific testimony is not only relevant but reliable. The court must make a preliminary assessment as to whether an expert is proposing to testify to 1, scientific knowledge, that 2, will assist the trier of fact to understand or determine a factor in issue. The court must assess whether the reasoning or methodology underlying the testimony is scientifically valid and can be applied to the facts in issue. Under 90.702, an expert may testify as to his or her opinion in a case if the testimony is based on sufficient facts or data, the testimony in the product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of the case. The court notes that this rule applies whereas here the defense does not rely on insanity. Clearly, testimony about the defendant's age and conditions is intended to show her lesser capacity relative to others. However, Evans also cites precedents for exceptions, including senility, to this general rule for conditions which are commonly understood and may be explained to the jury without the assistance of a mental health expert. It appears that Florida case law does not approve expert testimony even in cases where diminished capacity evidence is allowed. The court finds that admission of the evidence of the defendant's unique mental state when it is not relevant to a permissible defense or justification could invite confusion and potentially mislead the jury to excuse acts for which a defendant is culpable under the law. The theory of diminished capacity inevitably opens the door to variable or sliding scales of criminal responsibility. The rationale for the exclusion of evidence of diminished capacity is that it is too potentially misleading to be permitted routinely in the guilt phase of criminal trials. Okay, so that... Okay, so here's some of the case history here. Let's see this. The morning of November 1st, 2022, the defendant's daughter and the victim's mother, Kayla Nix, asked the defendant to babysit Uriel for the day. The defendant already had lunch plans with friends, but picked up Uriel and brought her to the restaurant. Video footage outside the restaurant shows the defendant and her friends leaving at about 1:42 p.m. and the defendant putting Uriel in the rear driver's side seat of a red SUV. Ring camera video from the defendant's residence shows her arriving home at 1:53 p.m. So that was 11 minutes, and leaving Uriel alone in the back seat. Several hours later, the defendant realized she had forgotten about Uriel. The defendant's husband attempted CPR on the victim and the police were called, but the infant could not be saved. The high temperature in the area that afternoon was 90 degrees. Defendant admitted to law enforcement that she forgot her granddaughter was in the back seat when she exited this SUV and entered her house. Let's see what else we have. The court was not presented with enough evidence by the state that the defendant. Hold on a minute. Okay, here's something about a proffer. Let me see what this is about. The defendant proffered the following at a hearing on September 19, 2024, without objection by the state. Defense proffer. On the day that the first child passed, the defendant was not feeling well that day. Nay Nicks, that's her husband, will testify that he went shopping. Yeah, this is what I remember. Ran some errands. He discussed this with his wife, the defendant, before he left. He will testify that she was asleep when he left, and he tiptoed out of the room. I think he said he was gone about an hour. He received a call from Tracy Nicks asking if he had the baby. It's Ezra. And he said no, and she immediately hung up the phone. He would testify that the cat could open the door to the garage, which goes into the house. He would testify that he had seen Ezra attempt to open a door. It was a double door, but it was deadbolted, and he did not open that door, but he did say he had seen Ezra attempting to open the door. It is the defendant's actions or inactions that form the basis for collateral evidence to be admitted, not what someone else could have or should have done. The state did not call nor present any evidence of redacted parents' instructions to the defendant that she was the sole caretaker of the child on December 22nd, 2021. That's when the child drowned. Let's see. Are you all going to Tampa or wherever the helicopter is going? Are you all going to Tampa or wherever the helicopter is going? Tracy, yes. Okay, all right. Before you can leave, can you explain to me just what kind of what happened so we have it for our knowledge? Tracy Nicks says, we were in the living room. Word says, you and the baby? Tracy says, and Nay, that's her husband, had rocked him he was sitting in the rocking chair leaning over against, was it just you and the baby in the house? She says, well, Nay was in there too. Word says, were you awake? Was your husband went to the store? She says, no, shaking her head side to side. He must have left right after. No. Okay, but you don't know how long, you don't know when he left for the store because you fell asleep before he left? She said, I think the baby and I both had drifted off. Normally the baby would be in my lap, but Nay was rocking him in the chair and was just standing behind him, so he wasn't in my lap. So he got up, and I was like, do you know where the baby got, what door he got out? She says, the door was to the garage was open, and I've never known him to open those doors. Word says open as unlocked or open as ajar. She says open as an open. He got out those doors. They were open. Okay, Word says. She says, and I've never known him to be able to open those doors, so I don't know if Nay totally shut it. Totally shut. Was he asleep? Then they're talking to Nay. Was he asleep when you left the baby? Yes. He was asleep in the chair, and she was talking. Word says she was awake. Nay says yes. Okay, let's see here. Here's about the baby. So the baby was 16 months old when he was being watched by both the maternal grandparents. He was rocked to sleep by the defendant's husband. Then the defendant fell asleep while her husband was still present in their home. The defendant and the baby were sleeping when the defendant's husband left the house. in what the court is convinced of by watching and listening to the body cam footage of Detective Shane Ward taken on scene shortly after law enforcement arrived on scene. When the defendant's husband left, the defendant had no knowledge that she was to be the only caregiver for Ezra. The defendant's husband ran errands for 1 to 2 hours away from the defendant and Ezra. He left from the living room into the garage, went to his truck, and he did not close the garage overhead door. When the defendant woke up, the minor child was gone. There is no video of these events, no eyewitnesses, nor was anyone arrested or charged with the death of Ezra. Of further importance to this court is that the first call the defendant made after waking up was to her husband to ask if Ezra was with him. If she was conscious and saw her husband leave alone to Walmart, she would not have called him, as she would know he did not take Ezra with him to run errands. Now, I don't agree with that. You know why? Because that doesn't make a case. Because how does she know really how long she was sleeping if he got home and went somewhere else with the child? How did she know he wasn't out in the yard or down the road, or that doesn't make sense. If she was conscious and saw her husband, she wouldn't have called him. The clear and convincing evidence to this court has determined about Ezra's death that it seeks to introduce in this trial as collateral evidence was that the defendant was asleep when her husband left to run errands. The court reviewed in detail the body cam video and audio of Detective Shane Ward of the Hardy County Sheriff's Department. Excerpts are provided below. The entire body cam video and audio was submitted into evidence by the state as Exhibit 11. And that's what I just read to you. I want to see if there's any transcript of all right, let's see what this is. Hold on, I'm just trying to go through these. Okay, hold on a minute. Okay, go back. How many? Let me see. Okay, so I'm just trying to find. Let me do this over here. This would be. There's a photo of Tracy Nicks as she was put into handcuffs. I know there was like so much. I think we had all the police reports and everything. Let's see if we can get the. Hold on. Trying to see if I can get the transcript of possibly her police interview or. What is this? Why is it? Okay. And I still can't find out if they ever asked if she consumed any alcohol at that lunch, and cannot get that, you know. Mother indicted more than a year after her sentence. That's something else. That's what I wanted to see. In my opinion, the jury will find out about the first death after being released and realize they made the wrong decision. It's what people said here. According to what is being said on Court TV, a second-degree misdemeanor might be a 60-day sentence. Court TV said she's only facing 60 days as this is a misdemeanor charge, like something you would get at traffic court. They will have a lot of mitigating factors, but one big aggravating is the death of the first child. As I understand, if they can, and we'll bring that in. Not even, no, I didn't. Let's see, here we go. According to the Hardy County Sheriff's Office complaint affidavit, Tracy, 65, told the detective that after she drove home from lunch with friends on November 22nd, she just forgot about 7-month-old Uriel. Uriel's mother, Kayla Nix, had gone to get her hair done that day and had asked her mom to babysit. It wasn't until one of Tracy's grandsons arrived, the complaint affidavit said, that all of a sudden it came across her head that Uriel had been in the SUV all afternoon. Her husband, Nix, immediately began CPR. Temperatures in Wauchula had reached 90 degrees that day. The Lexus SUV was parked in the yard with the windows rolled up. Tracy, a former school principal in Hardy County, was charged with aggravated manslaughter. The pretrial hearing was scheduled for March 28th. Let's see here. She was busy practicing the piano while Uriela was in the car. The police report was redacted, but it appears the grandmother was on 2 to 3 medications with side effects. Whatever condition she was taking them for is redacted. 1 week after the incident, the deputy asked grandparents to come to the office for a formal interview. She said she wanted to put away her Christmas decorations first. Very strange. Maybe she was trying to buy time. No doubt, psychotropic meds. Believe me, I know of once I speak. I'm not disparaging her for having mental health issues. We all had them at times, whether or not they were treated with medication. I've taken them. Some medications prescribed for mental health conditions can make you forgetful. Even simply antidepressant medication. Makes me also wonder if her lunch with the girls consisted of alcohol. Thank you. That's what I've been asking. That, in conjunction with any psychotropic meds, could explain a lot. Falling asleep while the little fellow tottered off to the pond. Anti-anxiety medication, who knows? But this is not normal behavior. Okay. Let's see. The report also suggests that Tracy stated she had already fallen asleep with the little boy and the garage door had been left ajar before the grandfather left. Over his statement that she had been awake and he'd put a weight behind the door when he popped out. Though police obviously decided she was the one who was culpable, there has been more to this. Was she fit to have charge of the child? Did her mental health, medication regime, or cognitive state make her fit as a caretaker? Did she get assessed after the first time? Was there any red flags in her quality of care between these two incidents? Is it possible for 2 terrible accidents to happen without a significant pattern of negligence? The odds are long, but the universe will roll the dice somewhere terrible as the idea. and as little as people want to believe it. I think the investigation into her pattern of care will be needed. I wonder if she does show a pattern of dangerous negligence or absent-mindedness that the parents were aware of, if they will also catch some culpability. Grandparents and parents may differ in child rearing occasionally, but after one child's death, I would expect the parents, if they could ever bring themselves to allow grandma to watch their kid again, to take zero tolerance approach to any lapses. Someone said, I'd be inclined to believe that she didn't have ill intent, but that her medication, age, possibly mild dementia, impacted her ability to concentrate on child safety. I expect she had good days and bad days, or that her ability varies widely. This makes it hard for family to have the heart and even the type of information they need to treat her as incompetent. She should have been seen by a few doctors after the first child drowned. She never should have been left alone with the child that if she wasn't fully alert, not sort of napping. So many coulda, woulda, shouldas to agonize over for the rest of their lives. Okay, someone said they would be interested. They want to know the dynamic of her relationship with her daughters growing up compared to other siblings. Oh, they want to know to Kayla as compared to the other sister. Did Dad have a special connection with Kayla that she was jealous of? Was she grandparents' favorite? Did she resent her daughter's happy family? I don't know if it could be a coincidence, but it seems unlikely to me that both Ezra and then the child Kayla was carrying at the time of Ezra's death are both dead through Grandma's negligence. Her story about Uriel's death doesn't ring true for me at all. I also wouldn't feel comfortable leaving my new baby with my mother if one of my children had died in her care, unless of a natural cause or underlying illness. This is not meant to victim blame shame at all. What child doesn't want to trust their mother? I just wouldn't be able to do it. She then drove to a restaurant for lunch with friends, according to the documents. They left the restaurant at 1:40. Security footage showed her put her granddaughter in the back seat. Authorities say she drove about 10 minutes to get to her home, parked the car, and went inside to talk to her dog and practice the piano. She told the Hardy County Sheriff's Office that it was not like I was rushing in the house to do anything. I just forgot. The court filing said that Tracy Nicks was waiting for her older grandson to arrive so they could go out to dinner after 4:30 p.m. She took 2 cups of tea out to her vehicle for her and her grandson, and then drove the vehicle to her backyard. She took 2 cups of tea for her and her grandson out to the vehicle and drove it to her backyard and still didn't realize that Uriel was in there. Authorities say Nix's husband was in the backyard, and the two talked for about 10 minutes. Now, did she have the air conditioning running at this point? When the grandson arrived, Nix said all of a sudden it came across her head that Uriel was still in the car. Nix's husband immediately pulled the baby out and began CPR while someone called 911. Let's see here. Another thing that seems strange to me is why didn't Kayla call or text to check how Uriel was doing? I always checked everything was okay with my mom or anyone had my kids, and if one had already died on her watch, I would be constantly on the phone. Well, I wouldn't be. I wouldn't have trusted her again and left my baby with her, but hypothetically speaking, I wonder if Kayla did check, and that's where things get much more complicated. Okay, let's get the affidavit here. Okay, let's see. I responded to the incident location, a dwelling property, in reference to a child drowning. EMS was on scene tending to the victim on my arrival. The homeowner's Nicks was outside, and he told me his wife, Tracy Nicks, was inside changing clothes. I determined the following series of events based on statements made to me by Nicks and their neighbor. The victim was being supervised by his grandparents, Mr. and Mrs. Nicks, at their home. No one else was at the home. There is a large pond that is stocked with ducks located on the west side of their property within feet of their home. Mr. Nicks was rocking the victim in a recliner in the living room. His wife was on the adjacent sofa. Mr. Nicks stated he left the victim sleeping in the recliner and left his wife, who he said was awake, to go to Walmart and run some errands. Mrs. Nicks corroborated this, but told me that she drifted off to sleep and was not awake when her husband left. At some point, Mrs. Nicks awoke and couldn't find the victim. She told me the garage entrance door was ajar. She searched outside for the victim and drove her vehicle to the end of the driveway and looked down. At some point, she called her husband and informed him that she couldn't find the victim. She said she turned around to drive back to the residence and she saw the victim face down in the pond. She drove over to him and pulled him out of the water, started CPR that she had been trained on from working from the school system. She did not call 911. A neighbor heard her screaming and told me she saw Mrs. Nicks giving CPR to the victim on the ground. He said her vehicle was parked along the fence in the front yard, consistent with her statements. He never saw the victim in the water, nor did he see Mrs. Nicks pull the victim from the water. He stated that when he returned to the yard, Mr. Nicks had arrived and joined Mrs. Nicks in performing CPR. Mr. Nicks consented for me to enter his home. He showed me the living room layout and described where everyone had been seated. He confirmed that he used the garage door to leave the home. I advised him that his wife stated she found the door ajar, and he shook his head and said he closed the door. I asked Mr. Nicks how much time had elapsed from when he left for Walmart and when he received a call from his wife. 15, 20, 25 minutes? He said it could have been up to an hour. I measured the distance from the floor to the door handle as 35 inches. The handle was a pull handle and not a knob-style fixture, which could have easily been opened by the victim if they could reach down to pull on it. I asked Mr. Nicks if they had any issues with the victim opening doors, and he indicated interior doors. I was informed that the victim was airlifted to TGH with a faint pulse. Both parents were called by Mr. Nicks and responded to the scene prior to the victim being transported. I checked the CAD system and found no prior incidents involving child abuse or neglect. At this time, the incident appears to be a tragic accident involving non-criminal negligence. In order to establish the elements of child neglect, the defendant must expose the victim to personal injury through culpable negligence. End of report here. The victim would be examined by the medical examiner and records could be obtained Let's see. Here's the about the SUV incident. On the above date, I responded to Hardy County, Florida, to assist with this incident. Upon arrival, I activated my emergency lights and parked my patrol vehicle in front of the residence. I directed traffic around the helicopter landing zone. While directing traffic, a white SUV arrived. A female subject exited the SUV and verbally stated she was involved. Oh, this is when she was involved in a traffic crash, believed to be at an intersection. The subject verbally stated she left the traffic crash to come check on her child at this location. I directed the subject to the residence. I forwarded the traffic crash information to dispatch. Dispatch advised that they're aware of the traffic crash. I then responded to the intersection. Upon arrival, I observed 2 wrecked vehicles at the intersection. Deputies were already on scene, providing aid to the subjects involved in the crash. I parked my patrol vehicle in the intersection and directed traffic around the crash site. I provided dispatch with tag numbers for both of the wrecked vehicles. Hardy County Fire Rescue arrived shortly after. I continued to direct traffic in the intersection until fire rescue cleared the scene. I have no further involvement in the case. Okay, let's see here. Okay, listen to this one. On the above date, this is 12/29, which would be 7 days after the drowning. On the above date, I arrived at the incident location and took some photographs. I met with Nun Nicks. Nun allowed me access to wherever I needed to take pictures. Nun was asked that he and Tracy come to the Hardy County Sheriff's Office for a formal interview. Tracy asked for it to be tomorrow, 12/30/21, as she wanted to complete her packing up of Christmas items. I advised that it was totally up to them. They agreed on the time of 10 a.m. I finished up my pictures and left without further contact. The pictures will be entered into evidence. On the above date, the Nickses arrived at the scheduled time for their interviews. I spoke with Nun Nicks first, and this is a summary of their conversation. He and Tracy were both inside the home with Ezra shock. Nun was rocking Ezra in the recliner when Ezra fell asleep. Nun had some errands to run and he left. When he left, Tracy was awake. Nun stated that he pulled the door to the garage shut and placed a metal Dachshund doorstop behind the door. Nun said he does this because of Ezra being able to open doors now, and this helps to prevent Ezra from being able to do this. Nun stated that Ezra did not like water and he hated getting a bath. Ezra was mobile and walked around the family home freely. Nun and Tracy would monitor him, of course. Nun stated that he would take Ezra on the side by side and see the ducks excuse me, and rest of their animals. Nun said that Ezra was able to grab door handles and open doors. Nun stated that he has seen Ezra grab the door handle of the double doors inside, and deadbolt was the only thing that prevented him from getting the door open. Nun stated that he left and was gone about 2 hours. Nun left and got gas. He said he went to the bank, then grocery shopping at Walmart. He got a call from Tracy and was completed checking out on his way home. When Nun arrived home, Tracy was still in her pajamas and giving CPR to Ezra. Nun told Tracy that EMS would soon be there to change clothes. She left and went inside. Nun stayed with Ezra and continued CPR until EMS arrived. Next is the summary of the interview with Tracy Nicks. Tracy stated that she and Nun were both in the home with Ezra. She thought it was special that Nun was rocking Ezra in the chair. Tracy said that Ezra fell asleep and Nun needed to run errands. He left. Tracy stated that she was sitting with her feet up, and she then ended up falling asleep. Tracy stated that this most likely happened due to something. Tracy stated that this can cause her to be tired. Tracy stated that at night she will take something and something for something. Tracy stated that she has been taking this regimen for about 15 years, and when she wakes up, she's refreshed and wide awake. She was not sure what made her fall asleep this morning. Tracy stated that normally when Nun leaves, he puts the metal door stopper up against the door because their cat can open the door. Tracy stated that Ezra cannot open doors, and therefore it was not needed for that. Tracy stated that she has never seen Ezra open any door in the home, and she was unaware he would be able to pull down on the handle-style door. Tracy stated that she woke up unsure of how long she was asleep and stated that she began looking for Ezra. The search then went outside, looking around the home. Tracy stated she got into her car and drove to the end of the long driveway, approximately 343 feet. Tracy then turned east and drove to the stop sign, approximately 817 feet. Tracy stated that she turned around and drove around the same distance. Hold on a minute. Gotta check if my watch is telling me something. Okay. 817 feet. Tracy stated that she then turned around and drove around the same distance, went past her house. Tracy then turned around, thinking that a 16-month-old couldn't have walked that far. Tracy stated that she believes that this is when she called Nunn. He was completing his checkout and was en route. Tracy stated that as she was driving back down the driveway, she's not sure why, but she looked over and had seen a white item in the pond. She wasn't sure what it was thinking. It was anything other than Ezra. She drove in that direction and realized it was Ezra. She jumped out of her vehicle and ran to the water. Ezra was face down, about knee-deep in the water. Tracy stated that she began CPR. After this is when Nunn arrived, and he took over CPR while Tracy changed her clothes. I remember the changing of the clothes. Like, that was so important. Detective Ward measured the door that Ezra came out of. The handle measured 35 inches. According to a medical examiner, Ezra's reach would have been 36 inches. The door handle in question is a lever-style handle. It has a downward swoop to it, putting the lowest point about 34.5. Looking at the door, there was a turnstile deadbolt on the inside, was the turn part with the key access part facing the garage. There was no toddler door handle, safety guard on this door, or any other door that I could see. I called Tracy via the phone as I needed the name of her medication, and she told me that she has one bottle of something, the blank and something else. Tracy stated that she was most likely went to bed at 21:30 or 2200 hours and woke up around 9:30 or 10 o'clock. A complaint affidavit for child neglect will be forwarded to SAO for further review. Okay, let's see what this is. The defendant, Tracy Nicks, did commit the offense of child neglect. The act of child neglect is defined as neglect of a child. A caregiver's failure or omission to provide the child with the care, supervision, and services necessary to maintain the child's physical and mental health. Okay, this was about Ezra. And this is the same report here now. Okay. Let's see. Okay, so I want justice for my son. She said, if I'm objective, she needs to go to prison. This is her daughter, Kayla. As her daughter, it kills me to say that. As their mother, I demand it. I will fight for them. Drew, that's the father of the children, said the whole reason they're sharing this story is that they want justice. I want justice for my son. I want justice because he didn't get that. And now I got to sit here and expose this. That way, I don't let what happened to my son happen with my daughter. And just get off scot-free because I couldn't live with that as a parent, Drew said. Kayla said she would want Ezra and Uriel to know that they loved them and that we're sorry because they were beautiful children and they were taken by someone that we believed was worthy of trust. Let's see. Trying to find this. Hang on. Okay, hold on. That's another kid. Ezra. Okay, here was our case. She wasn't thinking. She's 65 years old. She's not in the habit of being in charge of small children daily. Many 65-year-olds are more than capable of taking care of small children, but it very much depends on the individual. It's actually quite common for even parents to forget little ones in a car. This is someone's opinion. Thankfully, it usually doesn't result in death, but for a person who isn't used to having that day-to-day responsibility for a little one, and especially as we age, it just becomes more and more of a challenge. I don't think many young people are aware of what a difference 30 years is. 30 years old versus 60 years old is very different, at least in many cases. I feel terrible for the parents and the grandmother, but I don't think a charge of homicide is inappropriate. Homicide requires intention. She means appropriate, not inappropriate. And it sure seems like an accident to me. Why wasn't the grandfather also responsible? He's an adult, correct? When his wife took a nap, he should have been on duty. Well, apparently she fell asleep after he was gone. Okay. While in court on Thursday, Fox 13 reported that Nix's husband asked Hardy County Judge Reynaldo Ojeda to allow her to go to an inpatient facility in St. Cloud for 30 days in hopes that she would open up and talk about what happened. Nix's attorney, Drew Davis, also expressed concerns about her inability to discuss what happened after leaving Uriel in the car. Nix will appear in court again on June 22nd. This is from before. I'm trying to go back a little bit. Let's see what this says. Let's see. All right, let's see this now. So Nix is only being tried in Uriel's death, not Ezra. I don't remember reading that Nix was taking mind-altering prescription drugs when she fell asleep while watching Ezra. I feel there's so much more to this story. According to the reports, Nix and her grandchild reportedly left the restaurant around 1 p.m. and returned to her home. The defendant said she parked the car in the yard and forgot the victim was in the back seat, proceeded to go inside, talk to her dog, practiced piano for a long time because she had a piano lesson coming up on Thursday, investigators noted in the charging documents. According to reports, around 4:30 p.m., Nix got back into her Lexus, the infant in the back seat, and drove to speak to her husband on another part of the property. While speaking to her husband, she reportedly told investigators it came across her head that she forgot the infant in the car all afternoon. The defendant said she opened the back door and her husband panicked, got the victim out of the vehicle, and immediately started CPR. Baby's death occurred less than 11 months after the death of her brother, Ezra Shock, who drowned after reportedly being left unattended in Tracy Nicks's care. Ezra was found unconscious in a pond at Nicks's home on Kazan Road in Wauchula on December 22, 2021. The 14-month-old later died at Tampa General Hospital. As previously reported, the Hardy County Sheriff's Office sought charges against Nicks in Ezra's case. However, the Office of the State Attorney in Bartow declined the charges against the former principal. Nicks was taking mind-altering prescription drugs when she fell asleep and was watching Ezra. The daughter was all for her going to jail a year or so ago. I wonder how she feels now. I can't even imagine being in her position. Not just once, but twice. She won't. Well. How many Cymbalta and Ambien total did she take in a 24-hour period? Was she trying to kill herself? If she was addicted, why was she taking these medications? Was she taking these medications when Uriel died? I wonder what her everyday temperament was. Is husband supporting her in all this? Ezra and Uriel's parents are still fighting for justice for their babies. I wish them the best. Under the judge's instructions, Ezra's death will not be mentioned during Tracy's aggravated manslaughter trial for Uriel's death. Despite the fact that he is not allowed to be entered into this trial, we will have to come to a grip of closure in this circumstance. And so, regardless of the outcome, learning to find peace either way is going to be very heavy, Kayla said. I feel like if it's a conviction or a plea, then it might be easier for some, but I'm still her daughter. I still will sit down and I will still picture what that looks like for my mother, who is an older lady, and I'm grateful to the Lord above that my heart has not turned callous and cold and rigid. There's been years of interviews in court and signs and posts and just reaching and screaming and shouting and begging and pleading to be heard, to have a fair shot at justice for my daughter, Kayla said. Okay, let's see. I don't understand why Ezra's death can't be mentioned and explained to the jury, according to the appellate court, that was not enough evidence to establish culpable negligence, but that the two incidents do show a pattern. I mean, how did she get charged for Uriel's death if they didn't use Ezra's as establishing negligence? The jury could think of this as a one-off and find her not guilty. I really hope she pleads guilty and takes responsibility. Okay, let's see. Nicks's defense suffered several major setbacks last week. Judge Raffoul denied a last-minute request for the defense attorney, William B. Fletcher, to postpone the case or allow his office to withdraw from the case. Fletcher filed the request on January 2nd. The request cited the court's decision to exclude the defense's expert witnesses that were prepared to present evidence that Nicks suffered from diminished capacity to senility and over-medication by her physician. The decision to exclude the testimony was issued in a ruling by Judge Raffoul on December 23rd. The court sees nothing in the record to establish that the defendant actually suffers from senility. Raffoul wrote in the ruling, the experts would therefore serve to stack inferences that she is in fact senile and that the condition was exacerbated by inappropriate medication and or habit memory. Raffoul further noted that defense when arguing for the inclusion of the expert witnesses, was asked to explain the methodology of one of the witnesses and was unable to do so. Based on the above, the court cannot find that the expert's testimony is inadmissible. The judge ruled in his request for delaying the case. Fletcher wrote that the decision impacted the heart of the defense case. Defense counsel has spent over a year preparing its defense based on testimony of these experts. These experts made up the heart of the defense's case. Defense counsel cannot adequately prepare a new defense and be ready for trial by January 13, 2025. Fletcher also requested to withdraw his counsel if the matter was not postponed. In his denial of the defense's request to postpone or withdraw, Judge Raful was succinct. This case has been investigated and litigated by the state and the defense for over 2 years. This case is ready to be tried by a jury. It would be a disservice to relegate the defendant back to square one with completely new counsel simply because her current counsel anticipated prevailing against the state's motion. Defense counsel miscalculated. However, the court does not accept counsel's assumption that I can no longer effectively represent the defendant. Okay, hang on one second because I just have to do something here. Let me see here. Just had. Okay, good. All right. Let me go to the chat because I think it's getting late. And hi, Gail B. I haven't seen you in a few days. Thank you, Gail B. Okay, now Gail B. Gail B, thank you. I don't know if you yesterday I talked about how grateful I am for the community members and everybody that's here. And I said anybody that I missed, and I'm sure I missed a lot of people. But as they come in, I want to talk to them about what they mean to me. And Gail B, you're a very special person to me. You always have such a kind heart. You are always there to help anybody. You're the way of you that you speak is calming to a lot of people, and you're always there to lend an ear to help someone. And you've been a very great support for me. You've been here for years. I appreciate that. You've been loyal and nice and always ready to help, and I appreciate that. And I know that we are on very different time schedules, but, I just am so grateful and thankful for you being here. Thank you. And I just wanted to express that to you. Thank you. And I appreciate you. And I love you. Hey, Murder of Crows, how are you? I'm thankful for you being here. Your name brings a smile to my face. Thank you for being here. I enjoy your participation in the word games, and I really am thankful for you. Thanks for coming in. We did the other word game, but to end it, let's do one of the, go on with the regular one. Oh, you're welcome, Gilby. Let's see, maybe we can elk, buck, no. Oh, ink maybe. No, we did ink. I already have our, I'm thinking about making some Alfredo noodles. Okay. I'm hungry too. I'm hungry. Did you ever make that chili? Did you use that Instant Pot? I bet not. If I was a betting woman, I'd bet not. Did you use the Instant Pot? You didn't. I know you didn't. I know you didn't. Don't lie to me. No. I don't think you did. I don't think you did. I don't think you did. Okay. Not yet. I knew it. 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 What's why? Why? Kevin Leonard, little lady, tell him that he has to use his Instant Pot. Tell him that. Everybody, every day, badger Kevin that, did you use your Instant Pot? Did you use your Instant Pot? Badger him every day. Why didn't he use it? Why didn't he use it? Today or tomorrow, make a pot of chili. Oh my gosh, you were supposed to do that days ago. Come on now, please, just use it. I think I tried Inker. Yep. Like her, I'm pretty sure I tried that too. Yep. I tried Biker. Ilk, okay, that was one. I just gotta get this one. Bilker. That was there, but it wasn't there. Oh, Inkle. Inkle? Lichen. Yay, we did it, we did it, we did it, we did it in a minute. That was a hard level, it said. Huh. Aces? Your aces, Joni. That's good. Because aces beat kings. Not in Hollywood. Not in Hollywood, dear. Clues. Okay, heart made wise. Aces beat Hollywood. Aces beat kings. Not in Hollywood. Not in Hollywood, dear. Not in Hollywood. Sauce, sauce, sauce. She's on the sauce! Okay, here we go. We did it. And we're going to stop there. And I love you guys. And God bless. And prayers. And stay well. Be good. Be nice people. Do nice things. Make the world a better place. Go out there and make it happen. I'll see you later. God bless. Prayers. And I love you guys.